Welcome to the second podcast of the Super Yacht and Business Aviation Think Tank. We will be analyzing how is the use of a temporary admission customs regime in Italian waters, from the practical approach and enforcement at port level to the analysis and resolutions of Italian courts. And in this regard, we have a group of top experts, tax practitioners based in Italy, that will be driving us into this problematic. We hope you enjoy this conversation. Thank you.
Good afternoon. Here we are with a very interesting topic about a customs issue related to the yachting market. We have with us, maybe all of you, most of you already know me, I'm Carla Bellieni, and I have the chance to have with us this afternoon Marco Turci and Luca Calzolari, lawyers in Genoa, which addressed a very, very interesting topic in tax and customs litigation related to a yacht exceeding, or at least the customs authority raised an issue about the possibility that the yacht passed the period of discharge allowed for the temporary admission, and they will allow us to better understand this recent decision, and I will leave them to specify the details of the second instance of this decision and the past situation. I just leave Marco and Luca to briefly introduce themselves to our audience. Please, Marco, go ahead.
Yes, Marco Turci, lawyer in Genoa, specialized in the shipping custom market, working unfortunately since 40 years in this area.
Well spent time in your profession. And Luca Calzolari?
Well, I'm Luca Calzolari. I work with Marco in the same law firm. So I also, let's say, specialize in maritime and connected matters, I would say, including yachting and VAT. And I'm also a professor of EU law at the University of Turin.
Thank you, Marco and Luca. So what are we discussing today?
Very briefly, thanks, Carla. As you anticipated, the subject of this talk is the ruling issued by the Liguria Tax Court of Appeal number 200 of 2026. The ruling at stake concerns the so-called temporary admission regime provided for in the Union Custom Code, inter alia for pleasure yacht flying the flags of third countries. In particular, the Court of Appeal's ruling clarify an aspect concerning the interruption of the relevant time limit for the discharge of a temporary admission procedure, on which, as far as we are aware, there are no published precedents to date, either from Italian courts or from European courts.
This is absolutely one of the reasons for which this ruling is so interesting. And what does the temporary admission regime foresee, and the reason why it is the ruling is so interesting? Luca, maybe.
It's the same.
It's the same. Luca, please go ahead.
Okay, well, I believe actually everybody here knows what the admission regime foresee, but very shortly, the Union Custom Code, let's say, allows under certain condition for foreign yachts, for foreign pleasure yacht, to enter into the EU territorial waters without being subject to VAT or custom duties, in case there are custom duties at the moment. Of course, there are not. Under this regime, pleasure yacht may remain in the EU water for a period up to 18 months, according to Article 217 from the Commission delegated regulation from number 2446 of 2015. Let's say, in order to have a clear date from which the period begin to run, owners may submit an application to the relevant authorities, for example, in Italy, the Harbour Master Office, but this is not strictly necessary. because and this is relevant for the case at stake, so that's why I'm recalling this issue. Unless a yacht is explicitly and expressly declared under another custom regime when it entered the EU territory, unless this happened, then there is a presumption according to which the yacht is subject to the temporary admission regime just from the moment when it crossed the border, the external border of a member state. So it's an automatic regime. Of course, there are possibilities to, let's say, renew this 18 months period, for example, in case of refitting services or similar situation, but unless one of these exceptions applies, at the end of the period, a yacht is supposed to let's say, to leave the EU waters before the expiry of the period.
Very interesting. So non-European flag, non-European custom status for the yacht. And what happens if this 18-month period is exceeded?
The answer is unlikely to be exactly the same for all member states. Of course, we can speak about Italy, and in Italy, owners may face tax and criminal liability, of course, if they do not make a proper declaration. On the one hand, customs may take action to recover VAT on import, which becomes automatically due if the yacht remains in European water for more than 18 months, as Luca reminded, because she is to be covered by the temporary admission regime, and this is considered automatically imported in the European Union without a declaration and without a payment if the time limit expire without action by the owners. On the other hand, if the unpaid taxes, VAT and duties, if due, exceed certain thresholds, which are quite low when we speak of yachts, the conduct is also of a criminal nature and may be subject to criminal proceedings.
Okay, and did this happen also in the case at stake?
Yes, indeed. Essentially, at the beginning of 2022, the first to act was the public prosecutor in Imperia, which started a criminal proceeding for smuggling against the owners of the yacht that we defended, as well as other persons such as the captain and so on. Of course, the criminal side of the case concerned this alleged smuggling, but let's say it was based on the very same facts, which essentially were related to the equally alleged VAT, not payment of VAT. So the yacht was immediately subject to a criminal seizure by the public prosecutor office, essentially because under Italian law there is an obligation of a final confiscation should the criminal proceeding end with, let's say, a guilty verdict. So the provisional seizure at the very beginning of the criminal proceeding is, let's say, necessary, is mandatory in order to be sure that at the end of the procedure, the yacht is still there and can be confiscated. But of course, it's very, let's say, annoying for the owners, let's say so. And shortly after the criminal proceeding began, the owners also were served with the tax assessment, the Imposition Act by the Custom Office in Imperia, and the Customs Authority were seeking the recovery of the import VAT allegedly due on the import of the VAT. This is essentially, to keep it very short, a consequence of the so-called dual-track approach to criminal and tax justice in Italy and actually in other member states.
Very, very interesting. And let's go then to the reasoning behind the Imposition Act, the motivations for the first and for the second CART degrees. So we have 3 steps, the tax assessment, the Imposition Act, and the 2 degrees for the tax CART.
Yes, just to widen a little the scenario, we are speaking of early 2022, when the Imperial Custom Office was very active in targeting any yacht and super yacht berthed in that area of Liguria as part of a very first round of sanctions against Russia. As a part of this blanket investigation, they also searched the yacht Nuvag, and upon reviewing the documents on board, custom officials found out that the yacht had entered the European waters in July 2020. They established that the discharge period had not been interrupted since then, and being passed more than 18 months, they issued the Imposition Act claiming import for VAT for around 600,000.
So the first act was the Imposition Act, before the seizure.
Yeah.
Okay. And what was the position of the owner when they received the Imposition Act?
Well, actually, let's say the owner were very surprised, essentially because as it is standard practice in this sector, as let's say I think everybody knows here, they actually had provided instruction to their yacht agent to arrange for the yacht to sail to Tunisia in order to interrupt the discharge period. And they also received from the custom authorities in Tunisia some documents confirming that the yacht was there and stayed there a couple of days, as again is standard practice in order to interrupt the discharge period. However, let's say the Italian custom authorities thought, and actually we carried out by ourselves investigation directly in Tunisia, and we found out that those documents were forged. So it was really unexpected that, let's say, the temporary admission period was exceeded because the owner were fully convinced to have followed the usual approach.
All the rules.
Yes, and I also let's say reminded this profile essentially because this standard practice, with a term with which I refer to, let's say, the practice of going to the port of a third country in order to interrupt the discharge period, is precisely one of the main elements that has been discussed by the tax court of Imperia and of Genova as a second instance court, and this practice may change in the light of the judgment.
I understand. And if you had no proof of the yacht sailing to a third country during the 18-month period, what did you do? What arguments in practice did you raise to challenge the Imposition Act?
Okay, well, we were quite surprised as well, because at the beginning, I mean, the owners, our clients said, well, everything is fine. We went to Tunisia, so there will be no problem. This is just a mistake. When we found out that the documents were, the trip to Tunisia was not organized, we, let's say, started to look at the matter more in detail, let's say so, and we also had a look to the satellite data. And the data showed that the yacht actually sailed between Liguria and Sardinia, and then on the way back between Sardinia and Monte Carlo during the summer of 2021, in June and July. Since the customs authorities were claiming that let's say that the first time, the yacht entered into EU waters was in July 2020, this trip, let's say, between Liguria and Sardinia and Monte Carlo was, in theory, occurred in theory at the time, which was suitable to interrupt the discharge period, because it was before the end of the 18 months period.
But Liguria, Sardinia, Monte Carlo are all EU territories. We all know that they are all EU territories for customs purposes and VAT purposes, of course.
Yes, indeed.
So to summarize, your argument was that simply entering international waters is enough to interrupt the clearance period for temporary admission?
Yes, exactly. Because I mean that what we noted, our starting point was that in order to go from Liguria to Sardinia, you have no alternative than crossing international water, which, as everybody knows, lies 12 nautical miles of the coast.
Okay,
Let's say we thought that after all, let's say the fact that according to the practice, operators, generally speaking, goes to third country, have a yacht berthed for a couple of days in a port of a third country is just, let's say, something which has developed for evidential purposes. It's a way to have clear documents in order to show to the custom authorities in a following moment that the yacht actually exit the custom territory of the European Union. However, let's say our point, what we thought was, let's say that what is valid for ad probationem is not necessarily valid also ad substantiam, and sorry, apologies for the use of Latin. Let's say if we read the relevant legal framework, in our opinion, no provision of EU or national law make exit from the Union, from the EU territory, conditional upon the entry into the territorial water or let alone the port of a third country in order to, let's say, determine the interruption of the discharge period. The relevant provision, very shortly, are, for example, Article 215 of the Union Custom Code and Article 141 of the Delegated Custom Regulation. The first refers to exit from the custom territory of the Union, and the other simply make a reference to crossing the border of the custom territory of the Union. It is the second provision that I quoted, Article 141, is, let's say, the most important one, essentially because it refers explicitly to goods, including yachts, of course, subject to the temporary admission regime. Essentially, let's say, it codifies a very simple principle. Just as entrance of a yacht, as we were discussing earlier, of a yacht into EU waters automatically triggers the temporary admission regime unless the yacht is explicitly assigned to another custom regime. So too, let's say, the exit of the yacht from the same custom territory of the Union cannot but result in the automatic discharge of that regime. Essentially because leaving the territory is correspond per se to the yacht expert.
Very clear and very interesting for our audience because we need to go further into details on this very interesting key point in the end about the end of the discharge period. But was this very interesting argument upheld in the first instance ruling issued by the tax court of Imperia?
Well, actually, that would have been too easy, let's say. So, of course, not. Essentially, the court of first instance held that the temporary admission regime can only be interrupted with the export of the yacht, and the court established that in order to export a yacht, you need to arrive at the port of a third country, of a non-EU country. However, let's say what is also interesting to note is that the tax court of Imperia did not refer to any provision supporting its view. I mean, I briefly reminded the wording of Article 215 of the Union Custom Code and Article 141. If someone will read the text of the first instance court, there are no provision quoted at all. Essentially, the court said, and I quote the text of the ruling, that it was going to decide with an assessment which is deemed logical and in accordance with common sense. So they thought that this common sense was let's say, that saying that you need to reach a port in a third country was common sense. And apparently this was done in order to reduce alleged anti-avoidance objective that the opposite rule could, in the opinion of the Court of Imperia, originate.